the letters from last week. As I recall, I want to make sure that everyone here that was here last week agrees. This was the Cheekwood matter, and the main issue that we were wrestling with was whether or not the plans could go forward and we would approve without a licensed engineer stamping them. And what I recall us deciding and approving is that we would we would approve the variance, but not the specific request that a licensed engineer not sign the plans. Is that okay? The letter reads as if we are approving and that a PE does not have to sign the plans. So we need to make changes, I believe, to the minutes and the approval letter that makes it clear that that condition was not approved for a variance.
That's how I remember it as well.
Okay. I'm concerned with saying we approve this provided that change is made, because that's a pretty significant change.
I guess I'll make a motion that we update the minutes to reflect the initial condition is that we would approve the variance, but that it needed to be signed by the engineer.
Yeah, I think. Steve, is that going to be an issue, that change?
So I'm looking at it looks like it was approved, we have written for 1, 2, and 4, which excluded 3 on the document I'm looking at.
Are you looking at the letter or the minutes? Are you looking at the same document, Sam?
Be it resolved by Metro Stormwater Management Committee?
Yeah.
The letter and the minutes are not the same.
Okay.
So the minutes don't reflect. Oh, yes, they are. I'm sorry. I missed
Where do
that.
you say it's only approving 1, 2, and 4? Can we put a statement on there that makes it clear? I read the letter. It's not clear to me that when I read it, it just looks to me like everything's being approved.
Staff is absolutely clear of the conditions that were approved. If you'd like us to look at the document once more, we could do that.
Okay. That being the case, I didn't read it that way, and perhaps that's my fault. Do the minutes, Deborah, those not reflect that either? I mean,
No, it doesn't.
I didn't pick that up. Maybe
on
that's the
page
reason. I
2.
read the minutes first and then read the.
No, they're exactly the same. I was mistaken.
Oh, I see that number 3 is missing.
So it's implicit, that's what the staff say.
Yeah. If we could, well then
Yes, if it could reflect on, after discussion, number 3, that the drawings need to be signed by a licensed engineer.
yeah, I think a new paragraph, yeah, I think that's right. I agree with you. If we put before, now, therefore, a new paragraph that says, that makes it clear that the licensed engineer has to sign the plans. I believe that's probably what your motion.
Yes, that was the motion.
All right. That being the motion, and make that change both to the minutes and the letter. So in the minutes, it would be just right before, after discussion, or maybe at the end, before, at the very end, just add a line that says the approval requires the signature of a licensed engineer on the plans. So with those two changes, we've got a motion to approve the minutes and the letters.
I second.
Got a second? Any discussion? Seeing none, all in favor?
Aye.
Any opposed? Seeing none.
I'm going to abstain since I wasn't here.
Sounds good. All right. I think we're probably ready to move to our first matter. Battlefield Drive. If the applicant would like to come up and sit at the table. Ms. Gilbert, if you could read into the record the statement on appeals.
Our opening statement to the applicant. If you're not satisfied with the decision made by the Stormwater Management Committee, you may appeal the decision by filing for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the committee's decision. You are advised to seek the independent advice of legal counsel to ensure that your appeal is filed in a timely manner and that all procedural requirements have been satisfied.
Thank you much. Now we'll turn the floor over to the applicant for a brief presentation of the variance request.
Oh, there we go. See,
Mr. Chairman, do you want us to present the case real quick?
That's probably a pretty good idea. We got a lot of stuff on the list today. I'm trying to move along, skipping parts of the mass. All right. I apologize.
that's fine.
Staff, if you could
Whoever wants to is more than
give a
welcome.
quick summary of the request.
All right, the first case on the agenda is case number 2018-00022, 1547 and 1549 Battlefield Drive. The APN numbers are 117083A00100C0 and APN 117083A00200C0. The inspector is Kimberly Hayes, Council District 25, under Russ Pulley. Applicant's request is to allow the following: mow and maintain area within the buffer. The appellant is Aspen Construction, represented by Emily Johns. Comments: stormwater staff had no comment provided. Codes: no comment provided. Planning: site is zoned R10, defer to stormwater for review. Greenways defers to the comments of the Stormwater Management Committee.
Thank you. Now we'll move to the applicant. The floor is yours.
Okay. Basically, I just would like to give you a little history of the lot and our purchase of the lot. We bought it quite a while ago. When we bought it, we did our due diligence, everything checked out fine and clean, and after we bought it and closed on it, it was then that the stream in the front was classified as such, and so then we were surprised by this buffer situation, which is fine. So we just had a little bit of a curveball, and so now we're trying to figure out the best way to accommodate all parties, and so our landscape plan, can we flip to the landscape plan? Here we go. So originally, there was a huge amount of driveway and pavement in the lot right there. And it's all sod, just all grass. What we're proposing to do is take out about 500 square feet of that pavement, improve the permeable area within the buffer, and landscape it according to this diagram here. I don't know if you guys can zoom in. Yeah, most of that will be a lot of minimal maintenance. We're asking for a very little bit of sod just because it is in the front yard in this residential neighborhood. We feel like that's fitting. It's at the furthest point away from the buffer, so we're trying to keep the water as clean as possible. So we're asking for a very minimal amount of mowing and maintenance. And that's basically it.
Thank you. Is there anyone here from the public to speak either in favor or against the variance request, or opposed to? Seeing none, turn the mics over to the commissioners and for questions and discussion.
Okay, I'll start and get us rolling. Where's the building footprint in comparison to the buffer in this diagram?
It is very far back. It's so far back you can't even see right there. We go. We're not building anywhere near the buffer. We're very pushed back. In fact, our original plan, before we knew of the existence of the buffer, we were up closer where we would be for the minimal front setback, and we've pushed them back just to allow some more room there.
So basically, the new paved surface would be right on the edge of the buffer, and you're wanting to create a small grass strip between the pavement and the
Yes.
buffer? Okay.
And we're not adding any more pavement to the buffer area. All that's there is what was existing, and we're removing, in fact, some of the existing pavement.
How wide is that grass strip, staff? I didn't notice that either. It's like 5 feet.
I think that's about it. I don't have that measurement on me.
Okay, I'm going to make a motion.
I like it.
Move to approve as presented.
I second.
Got a motion and a second. Motion is to approve as submitted. Any discussion? For the record, before we vote, I would say that the variance request is well taken, given the restrictions on the lot and the minimum amount of disturbance within the buffer. That said, all those in favor of the motion say aye. Opposed? Seeing none, the motion carries. Thank you very much. All right, second matter. Looks to be, where's the name of this one?
Trey Moore.
Trey Moore. Thank you very much. If the applicant could come up and join us at the appropriate spot. And we'll start off with staff giving us a brief description of the summary.
Thank you, Chairman.
Summary of the request.
Case number 2 is 2018-00023. It's Trey Moore Village, located at 2225 Trey Moore Village Way. The parcel number is 114-070A-90000CO. This is the open space. The inspector is Lee Nelson, and this is Council District 22, Ms. Sherry Weiner. The project was first granted a variance in 2006. It was 2006-084 on August 3rd, 2006, to allow 2 drain crossings within the floodway and the floodway buffer of tributary number 1 to Overall Creek, and an over 40-acre drain, and to allow buffer disturbances to drain 3 proposed water quality/detention ponds, and to install water lines as were highlighted in the plan of record. The location has been occupied for several years without final sign-offs. The floodplain cut and fill needs to be balanced. There was more fill than cut placed. The variance that is being requested at this time is to balance the site. There is an option for the applicant, however, not the requirement of Metro Water Services. So the applicant's request is 1, 462.2 cubic yards of uncompensated fill material placed within the floodplain of tributary 1 to Overall Creek, associated with the original development that occurred in 2010-11. The applicant is Mike Phillips with Neil Schaefer, being represented by Matt Williams with Beezer Homes. Stormwater comments. Staff has been working extensively with this grading permit site for a lengthy period of time in an effort to grant a final sign-off on the permit. In an effort to reach an approvable as-built, the applicant has pursued multiple site solutions and performed several site surveys. After communicating that they have explored all options and that additional fill removal would impact buffer vegetation, staff recommended that the applicant take the remaining uncompensated fill amount for the Stormwater Management Committee. Codes provided no comments. Planning site is constructed. They defer to Stormwater. Greenways also defers to Stormwater. Thank you.
Thank you. We'll turn it over to the applicant now.
Mr. Chairman, members of the committee, my name is Tom White. I'm an attorney with Toon, Entrican & White, represent the applicants that are here today. It's basically a combined application. Trey Moore is the name of the development. Beezer is the developer. And sitting to my immediate right is Matt Williams with Beezer, and to my left is Mike Phillips, who's here with respect to the Neil Schaefer participation. I'll comment at the front end that this is a matter that has gone on for an extremely lengthy period of time. The grading permit was 2006. We've got a proposal here today which can be more fully covered by the 2 folks sitting next to me, but I can say that Stormwater is totally supportive from the staff perspective, and I've confirmed this with Dale Binder. I've confirmed it with Steve Mishu, and I had a brief conversation with Michael Hunt this morning. They would be very pleased to get this issue resolved. The issue that we've got here today is basically a mitigation by the landscaping that's being suggested, and we can cover that more fully. I did want to confirm that with me today also is Marshall Albritton, a good friend of mine who's the attorney for Trey Moore. Everybody's in total support, but I just wanted to make sure I identified this as that support. And also that this is, as indicated, District 22, this is Sherry Weiner's district, who's a very clear advocate for compliance. Sherry Weiner is totally supportive of this resolution. I think has communicated that to the staff. She certainly has to me and to Marshall Albritton as the attorneys here. With respect to what has taken place, I think it's absolutely clear that the facts are undisputed here. As this matter continued to go on, the bonds expired. Metro's bonds expired. So in some respects, with the bonds expired, there was relatively limited amount that Beazer had to do here, but they continued to work on this matter despite the bonds expired. Matt Williams inherited this matter in February of 16. Everyone I've talked to at Metro Stormwater, some of whom are present here today, also included other meetings with other representatives, were incredibly laudatory of all the efforts that were done by Matt to try to bring this matter to a resolution. And that can be explained here totally in front of the committee, but I did want to comment that at the front end, I don't know of anybody on the staff that's not just supportive, but euphorically supportive of getting this matter resolved. And so I'd ask Matt to basically pick this up at this point and say what took place from February of 16 forward.
Thank you, Tom. And thank you, Tom. I want to thank the committee for taking the time to hear our request this morning. We regret that we have to come before you with this request, but after working with staff and the community, we do believe that this is the least objectionable option for all parties involved. So brief history with Trey Moore since inheriting this in 2016, going back to look at the what's transpired. Since 2013, I believe Beazer has tried to honor its commitment for receiving its last UNOs and resolving the floodplain Lomar issue that is still present at Trey Moore. A couple of things, of course, came up that has hindered it, and it's taken far longer than ever expected. Things such as FEMA and the Corps of Engineers reevaluating the floodplain and the flood basin, so that delayed the final results of the flood study. But once the final results were able to be given and the studies were done in 2016, which identified the fill that had been placed that needed to be compensated for, Beazer immediately went to work with Neil Schaefer, who's one of the best stormwater consultants in Nashville, to come up with solutions and remedies to mitigate this issue. As we looked at areas to remove fill and to do the areas to remove cut to compensate for that fill, we started noticing that due to the amount of acreage that would have to be disturbed, it would be very devastating to the existing buffers. I don't know if those of you have toured Trey Moore. Trey Moore is a very beautiful neighborhood. They take a lot of pride and value in their landscaping and the natural feel that you have in the community along the creek buffers and the floodplain. And so as we started looking at the first option, it became apparent that to mitigate this route would actually have more devastation than benefit. So we started to look at other options, met with the community, kind of let the community know what was going on, and so they agreed that the impact to this solution would far outweigh the benefit. So we pursued offsite mitigation. We thought if we could find an area in the immediate basin that we could go do cut fill compensation, then that we could then stay the traditional course and avoid having to come before you today. But as we looked at any other, all the other areas surrounding Trey Moore, we kind of came to the same conclusion that any removal of cut would have the same devastating impact to the buffers just because of the shallow nature of the cut and how many acres would have to be disturbed. So since we know buffer preservation and, of course, the landscaping appearance of the community is very important to all, we started looking at pursuing this through an alternative measure and mitigate a different way. And so after being on site, we started noticing that there's areas that could use an enhancement. And I know it's customary with the Corps of Engineers or even TDEC that if you have buffer disturbance that you can do on-site mitigation via landscaping. So we thought this would be an appropriate solution. So to make sure that it was applicable, we hired Hebert & Ball, which is a well-known landscape architect that could evaluate the area and give us a landscape mitigation plan that would enhance the buffers in the affected area, improve the neighborhood, improve the landscaping in the community, which is very sensitive to the community itself, and then also suggest native plant materials that would make it relevant to this kind of solution. And so that's what we did. We engaged with Hebert & Ball. They came up with a landscape plan that's before you today, and we believe that's an option that would not only enhance the community, but be able to mitigate the impact, but in more of a positive manner. So we have, like Tom mentioned, we have worked with staff and worked with Council Lady Weiner and received full support, as well as the community who's here today. And we think that this is the best option to move forward with, and we look forward to hearing your response and hopefully your affirmative vote. So,
Mr. Chairman, I'd like to ask Mike to respond, if you would.
Good morning. My name is Mike Phillips with Neil Schaefer Engineering. And Neil Schaefer actually goes back to 2011 working on this project. We've worked with several project managers at Beazer through the course of this project. And so I just want to give you a brief history of the technical side of this project. I'll try to be as brief as possible, but we recognize that we can't come before today and ask for this variance without giving you a full history of the technical work that's been done. So that's what I'm going to try to do. So a stormwater grading permit was issued for this project in October of 2006. Under that grading permit, Metro did not authorize the placement of any fill material in the floodplain. Could you switch slides, please? There's actually a handwritten note on the approved grading plan that states that no fill should be placed in the floodplain until FEMA approves the conditional letter of MAP provision. So in essence, Metro was deferring to FEMA for approval of the stream crossing, which is a slab bridge crossing at Traymore Village Drive. Now that bridge crossing and roadway embankment actually accounts for about 50% of the fill material that we're before you talking about today. So FEMA approved the Clomar in 2007. So in essence, FEMA has already reviewed and approved, like I said, roughly 50% of the fill material that we are asking for variance for today. Next slide. So construction initiated after the Clomar was approved. Again, that Clomar was approved in 2007. And construction was completed in 2011. So the original plans called for a slab foundation construction for the townhomes on top of stem retaining walls. However, the walls were not built. The sloping embankments, therefore, for these fill pads, building pads, extend out into the floodplain, which accounts for the remainder, or roughly the other 50% of the fill material, aside from the road crossing. Next slide. So this is an image of the approved grading plan. One of the issues is construction oversight. We're not sure today, again, this issue predates all of us on this team, but we're not sure who was responsible for oversight of construction. But the fact is the slab or the stem retaining walls were not built. Those stem retaining walls were intended to keep the fill material out of the floodplain. So that didn't happen. So that's where we are today is attempting to get a variance for that uncompensated fill material that was placed in the floodplain. So the red clouded areas on this plan, the thin linear clouded areas show where the retaining walls were supposed to be built. Again, they're not there. And then there's a highlighted note in the lower right-hand corner that I mentioned that says, and we believe it's written by Metro, it says no fill material shall be placed in the floodplain without FEMA's, until the Clomar is received from FEMA. Next slide, please. So these images and this plan layout shows you, in lieu of the original retaining walls, you can see the sloping fill extending from the base of the townhomes down to the creek. Again, the retaining walls were supposed to hold that fill back. They were not built. And you can also see in these photographs that there's very well-established vegetation, mature trees. So it would be extremely difficult to do any excavation in these areas. And as well, you would disturb the foundations of the buildings. Next slide, please. So Neil Schaefer was hired by Beazer after construction was completed in 2011 to handle the as-built letter of map revision with FEMA. So once that application was completed, we sat down and met with Danny Smith at Metro, and he informed us that the Corps and FEMA were in the process of updating the Davidson County flood insurance study based on the 2010 flood event. And it was decided at that time that we should hold off on submitting the as-built letter of map revision for Traymore until that study comes out and we could evaluate it to determine if it incorporates the as-constructed subdivision. So that's what we did. Next slide, please. But in the meantime, while the FEMA study was being completed, and it took many years from that point, as Mr. Williams explained, we undertook a number of analyses, field surveys, tree inventories, hydraulic studies, mitigation plans to develop several alternatives for excavation within the floodplain. And we determined that all the options that included excavation would damage the buffers and could not fully mitigate the uncompensated fill. We determined that the maximum amount of fill that could be provided if we were to go that route, given the constraints of the floodway and the building pads and the trees, was only 310 cubic yards. So we would still be left with roughly 150 cubic yards, even if they moved equipment out there and moved every piece of dirt that they could possibly get to. We'd still be faced with an uncompensated fill variance, and we would be faced with about 0.9 acres of buffer disturbance. Next slide. Next slide, please. Furthermore, the hydraulic analysis showed us that when you excavate some of the fill material that's out there, the way that the hydraulic calculations work, due to the way the water flows through the overbanks, when you excavate those overbanks, the flow depth spreads out, the velocities slow down, but the velocities slow down so much that the water surface elevation actually slightly increases. So that was another detrimental effect of doing some of the excavation. We've kind of found that the sweet spot was roughly 200 cubic yards. Once you exceed that in some of these areas, the velocities slow down enough to have adverse impacts. So we come before you today requesting a variance from Section 5.5.6 of the Stormwater Management Regulations, which requires compensating storage capacity of at least an equal amount of fill material within the regulatory floodplain. So now we need to explain what are the impacts of this uncompensated fill material. So the 462 cubic yards causes between 100th and 600th feet rise in the 100-year flood elevation compared to the pre-developed conditions. That's roughly 3/4 of an inch. This 3/4 of an inch does not cause flooding of buildings nor roadways, and the only impact is to the common or HOA-owned areas. And the 3/4 inch rise is not detectable in the mapping on the 500 scale FEMA map. Next slide, please. So what are we proposing to mitigate the uncompensated fill material? As Mr. Williams explained, this is not a conventional approach, but due to exploring all the other options and not finding an equitable solution, environmentally, we are proposing 3 planting areas with native vegetation totaling about 0.4 acres to partially mitigate for the uncompensated fill material. It's important to note no grading is going to be proposed here. No grading will be completed, only clearing and removing the underbrush and the invasives. One of the planting areas, one of the 3, is beneath the TVA lines, and we've obtained written approval from TVA for the proposed plantings. Next slide. So the underlying premise of our variance request is that about a half of the fill material has already been approved by FEMA as part of the 2007 CLOMR, and the remainder of that fill material was incorporated into the 2017 FEMA study because their survey that was done for that 2007 April 2017 FEMA study. Their survey was actually done in 2011 after Traymore had been constructed. So therefore, the subdivision is already reflected on the maps, the FEMA maps, and this negates the need for further coordination with FEMA. And again, the fill we determined causes about a maximum of 0.06 of a foot rise. But that has been incorporated into FEMA study. So we hope that these facts, along with the proposed mitigation, will allow Beazer and the Traymore Village HOA to gain approval for the uncompensated fill material. And we thank you very much for your time and attention. And if there's any questions, let us know. Thank you.
Mr. Chairman, that concludes our presentation. We'll answer any questions, but I hope it's obvious we spent a tremendous amount of time trying to get to this resolution, which is clearly an equitable one, to my knowledge, supported by everyone that's looked at it, the council lady, the staff, my client. Thank you.
Thank you. Is there anyone here from the public to speak in favor of or in opposition to this variance request? All right, seeing no one here, but we've got an email that was sent in. Penny, if you could read it, please.
This was sent in by Council Member Weiner, and she states that Traymore Village property is located in her council district. Please share that I am totally supportive of the variance which is being requested in this manner. I am aware that this matter has been outstanding for a long period of time, and also aware of the time and effort spent by representatives of Traymore and Beazer to resolve this matter. My understanding is that the professional staff of Stormwater supports this request, and that this conclusion was favorably received by them as well. This development has been completed for some time, and the proposal of mitigating by landscaping is the very best solution. I have discussed this matter with representatives of Traymore and Beazer and have informed them of my support for the variance and my thanks for all for their efforts to resolve this issue.
Thank you. With that, we'll turn it over to the committee, and I'm just going to start off. I want to make sure I understand this. 2006, they came before the committee, and a variance was approved, but the variance didn't request any uncompensated fill.
In 2006, the committee did come for a variance, and there were several things that are permissible today with the regulations that were not at that time, and several requests that they were asking back then were permissible today that wasn't back then, and that's the main reason why they came over here at that time.
Okay. I think what's important before us today, I want to make sure, is that this committee never granted a variance from filling in the floodplain.
I do not believe so.
Right, and then they granted the variance to allow the stream crossings, provided they got their proper approvals from other agencies.
Exactly.
And part of that approval would be a no-rise letter, I'm assuming, on that.
Well, this kind of, like they were saying, it kind of predates a lot of people. I think my best guess was that this site was a balanced site.
That's why there were no requests, because they were in a balanced site.
Exactly.
But in order to do that, they had to build these structures on walls.
Right. So I'm not sure if the camera's going to get me, but it was supposed to be stem walls like this, and if there's a slab, there's no back door. I mean, you wouldn't have a backyard. So I think the builder was a slab builder, and they ended up building it with a slope. So now when people open their back door, it's not that 4-foot drop of a stem wall.
So they didn't have the plan didn't show any fill in that area, but at some point in time during construction, that's what was done. They filled in an area that wasn't supposed to be filled, and then they weren't able to get their use and occupancy. What brought them here today? Why are we here 12 years later? I mean, obviously there's people living in the townhomes.
We are here because of a gentleman's agreement between Beazer and PDS. Beazer has all their approvals. I think they have all their use and occupancy permits. But because they didn't finish the stormwater grading permit sign-offs, someone promised that they will get this addressed. And so even though Beazer's been out of this development for several years, because they promised, they have been chugging along trying to get approvals.
And the reason they couldn't get the sign, so use and occupancy permits were issued or temporary use and occupancy permits?
I believe they have all the permits that they have. Every permit they have is issued, except we haven't closed out the grading permit.
Oh, why do they care? If they got their use and occupancy permits?
I think they have all the permits. They just made a promise, and they're trying to fulfill their promise.
Okay. All right. And so the variance here is needed in order to get that check off on the Metro stormwater?
Yes, sir.
Okay. And and Metro has said they're not going to, according to the gentleman's agreement, Metro has said they're not going to check off the box until we grant a variance that says that they can have 400 watt-odd cubic yards of uncompensated fill.
So that was the last choice. They stated that this coming over here before you was the last choice. We suggested that they don't come to you until they explore other options. We've asked them to talk to the Dollar General next door. We've asked them to talk to other places. We told them to look at other undeveloped properties that they could purchase, and we've really been meeting with them for several years, and they've kind of explored those options, and nothing came to fruition on it. Just didn't work out.
All right. Okay. And the 0.1 or 0.01, 0.06 rise, that's based on what?
That's based on running field run cross sections. We obtained the effective FEMA study, incorporated our as-built topo into that FEMA study, ran the model, compared that back to pre-developed conditions. So that's not talking about as-built versus FEMA. That's talking about as-built versus pre-developed conditions, which is a little different than FEMA. So the no-rise certification you were speaking of, if we were able to meet no-rise conditions, the as-constructed versus pre-developed would have been 0. But due to the fill material in the floodplain, we have that 0.01 through 0.06 rise, depending on where you're at in the subdivision.
When FEMA granted the bridge crossing, was there a finding of no rise from the bridge crossing?
No, sir. That's why a conditional letter of map revision was submitted. Conditional letter of map revision allows increases with the acceptance and sign-off by the community. And so it's my understanding that the community signed the application, it was submitted, and it was granted. They did not show a no rise for the original. And that's just due, even though, like Steve said, they had a balanced site, you can't always get these hydraulic models to behave and show 0.00 rise. Anytime you're installing a new bridge crossing in a floodplain, you're going to be very hard-pressed to get a no rise. So they did show an increase in flood levels due to the stream crossing.
The 0.1 to 0.6 increase, how much of that would have been the case even without the other additional compensation? So in other words, the bridge crossing itself, how much of a rise did that show? Or has that analysis been done?
That analysis was done in for the 2007 Clomar with FEMA. I don't have that study memorized, but see, the increases that we're dealing with are kind of throughout the whole subdivision, whereas the original design with the bridge crossing showed slight increases immediately upstream of the bridge crossing, but then those settled out as you moved upstream. So in other words, there was a bump in the profile from their bridge crossing, whereas now we've got the bump plus we've got a little bit more due to the fill. But as for the actual comparison, I'd say, it's going to be, if you look back at the original study, it would be less than we're showing. But again, their increase was just at the bridge crossing, whereas we're kind of throughout the neighborhood, or where the fill material is placed.
Your 0.1 to 0.6 inch, you stated that didn't flood any buildings, and I can't remember what else you noted on your presentations. But I assume you're talking about within your development. Did you look at what impact that fill material had upstream further than your development?
Yes, sir. And there are no adverse increases upstream of our development. We tie back in at Charlotte Pike.
Trying to figure out which way the water's going. The water's coming from Charlotte to your development?
Correct.
Okay.
So we actually tie back in just downstream of Charlotte Pike. So there are no off-site increases.
Turn the floor over to someone else asking questions now.
I appreciate those series of questions, Mr. Chairman. That was very illuminating. So, we really struggle over these post-2010 flood. And I personally struggle over uncompensated fill because there are cumulative concerns. You know, the little ones we grant now added to the little ones we grant later become bigger ones, become significant ones. The insignificant, seemingly insignificant rises become significant rises as they accumulate in an area that changes the flooding situation. So I typically never vote for an uncompensated fill. And just to restate one reason why I do that, it's common for us to have public uses of property that we don't own the fee simple basis for, that we have a partial interest in that property, and that represents a public asset. And if we give that public asset away, the taxpayer is not being compensated for something they essentially have the right to use. And that creates benefit for the community. And we routinely have our council representatives who complain about selling property too cheap, giving away public assets too cheap. So that's kind of the basis, two of the basis for my concern. Now I've got a bit of a kind of an unusually detail-oriented kind of thing that I don't normally do. I don't like prescriptive inquiries about specific activities. In your mitigation, you're attempting to mitigate impacts to the buffer that have probably already been created more. You're not trying to mitigate the uncompensated fill with your plantings. You can't do that, but you are trying to improve the quality of the buffer. I noticed in your landscape plan you're using miscanthus, which is the common name is Chinese silvergrass. I'd really rather not give the President of the United States another reason to be mad at China.
Good luck.
So if we could avoid using an invasive plant, I Googled this on my phone. The Tennessee Plant Council identifies that as an invasive exotic that pushes out native Tennessee plants. The Southeast Pest Plant Council has labeled that as something they would rather not see continue to be used in the Southeast. So that's easily replaced with other species. I'm not going to prescribe to you what that should be, because then I'd be really getting prescriptive. But
the clients confirmed they would do that.
All of that being said, I think all of us admire your tolerance for the time frame that you've been dealing with, trying to honor prior commitments, and for the difficulty that you're facing, and we really appreciate the effort. So.
Okay. Exactly. I appreciate the fact that someone's trying to keep a commitment that they've made with Stormwater, and I think that there's an effort here to try to remedy and close out this project. I realize that there's uncompensated fill here, but if there's any impact on that, it only takes place within the confines of this development. When we're talking about community, the council member is clearly supportive of this. She represents the community, and therefore that satisfies me. I'm not sure what else you could really do at this point. It'd be just more disruptive to try to do anything other than what you're proposing. And so I think I would support your request. And with the exception of the invasives that my colleague talked about, if those could be swapped out with something else, that would be great. And so I'm going to make a motion to approve this based upon what I just said.
Been a motion to approve. Discussion can still go on, and anyone can second the motion also. All right. I'm still trying to figure this out. There were 2 stream crossings that were approved in the variance. I see 1 on here.
There are 2. I'm trying to find them now. There was one that Rebecca just had her hand on, right there.
Yeah. Sawyer Brown, I assume, was there already.
And then the second one, so Charlotte's there. Let's see. Probably going to help us out a little bit better. I think the other one's a little bit further away.
So it's not on the maps we see.
Downstream further away?
There we go.
Downstream further away or upstream further away?
Downstream.
Okay.
Is that the other one, or is that the same one?
Potentially, the other one was that 40-acre drain. I think there was a mention of a 40-acre drain.
Where is that?
That I do not know. Hold on one second.
Our regs, back when this variance came through, always you had to get a variance for disturbance to a 40-acre drain, whether or not it was a stream. We changed that in 2007. So it appears there was a 40-acre drain here, and that's probably what they received the variance for.
Gotcha.
That's correct. I believe that crossing is not in the flood zone. It was just a very minor tributary.
Okay. And then why weren't they required? I understand half of the uncompensated fill had to do with the crossing. And at the time, common practice would have been they got their letter, they get to do whatever they're doing there.
Yes, sir.
The other half of the uncompensated fill is from the slab wall issue.
Stem wall. Yes, sir.
Why at the time were they allowed to continue? Why weren't they made to remove? I mean, the reason we're here now is because you couldn't remove. Now it's going to be worse to remove it than it would have been. But I don't understand why 12 years ago they were allowed to go forward with the agreement that they're going to. Am I missing something here?
No, you're not missing anything. We've been working with them for a really long time.
The working with them, why wasn't it just you got to move it?
Well, that was part of the discussion. So as-bills were reviewed, I'd say probably 7-8 years ago, and it was determined at that time that hey, you have some fill in there that needs to be dealt with. And we've dealt with several people from Beazer since then, and not that it matters, but I appreciate Mr. Williams. He's the only one from Beazer that's was able to get this far to bring it here, but we've been dealing with several different individuals at Beazer at the time.
Okay.
Mr. Chairman, if I might offer something that might help you sort of understand. Obviously, there were a lot of things going on with this site, and while I can't speak specifically to this site, I can tell you that it's not unusual on land development sites for there to be in-process changes. And when we see those changes, oftentimes what we do is work with the permittee with the understanding that at some point they will come back in and be able to show we were able to do this, so we could do that. Yes, in a perfect world, that should have been called out, but it's not quite so simple as that we go out and every time someone deviates from a plan, we stop the work. In retrospect, obviously, there should have been more said earlier about this, but we do work with permittees on almost every site because as they start to develop, they encounter things that run out of necessity somewhat contrary to the plan. So generally speaking, that it's not unusual for us to see things not exactly per plan with the assurance that eventually they'll work with development services and make things right. I don't know to what degree maybe some of the FEMA issues contributed to this, but that would be some general information relating to that. I would also say as it relates to what's kind of been couched as a gentleman's agreement, it's important to understand that the mechanisms that we have in place relating to our grading permits to facilitate compliance, which are generally using the occupancy permit sign-offs and bond reductions and or releases, are means by which we facilitate proactive compliance with our regulations and the requirements. When, and thankfully it is very, very, very infrequently, that those systems fail for whatever reason, we still as staff are obligated to require the site comply with the regulations. It just means it's much more difficult on us, in this case, working for years and years and years to come up with a common solution. So in this case, staff can't just say, well, it got to this point and there's uncompensated fill. Go forth, we'll sign off on your grading permit. We still, at the end of the day, and in much counsel with our legal folks, we have to pursue compliance with the regs. Hopefully the systems that are in place always serve us well. They serve the permittees well. But I did want to be clear that in those cases where those systems, for whatever reason, don't serve us well, we still are obligated by whatever means is legally feasible to facilitate compliance with our regs, in this case, in particular, the uncompensated fill.
Okay, so what would that be? How can you enforce them to do this?
I think at some point it would end up probably going to environmental court.
An environmental court, and that's for building, not getting a variance to do the uncompensated fill?
Have an uncompensated fill.
So environmental court is a division of General Sessions Court that handles violations of the Metropolitan Code and has the authority to grant injunctive relief.
Mr. Chairman, if I might at least address as to how we got here today. It's a very peculiar circumstance. There's no precedent setting by the committee approving this today for the following reason. I don't know of many cases like this, but the bonds have all expired, not temporary. The permit has all been issued. Everybody's been out there for a number of years. The units have, in fact, resold on a number of occasions. And when I first met with Stormwater about this, which was maybe 9 months ago, they could not have been any more complimentary about Matt Williams and his role at Beazer in trying to get this matter removed, because it's been here since 2006. And we candidly said to them, the bonds are expired, the UNOs are all issued, but we're going to do whatever we need to do to try to figure this thing out. And I think those efforts have been really Herculean and exhausting the different things that Neil Schaefer and that Matt Williams have explored. So my comment is it's not precedent setting, and frankly, a lot of builder developers take a cavalier attitude that, everything's issued, bonds are gone. I don't remember a matter like this ever going to the environmental court. I'm in that court with some frequency. I don't remember a matter like this being there. But the practical matter is this matter, without setting precedent, would resolve this matter, in good faith, that the homeowner association is totally supportive of, my client's willing to pay for. The landscaping matters here are just short of $65,000, which they've committed to. They've escrowed the money with my law firm to do it. There's no lack of good faith here. So I would urge the committee to consider that, and consider if it's not granted, it's basically another could be another X years down the road. It doesn't make a whole lot of sense not to get it resolved today. And so I want to compliment Beazer for stepping up here. Whatever took place in the past, Matt Williams has spent a tremendous amount of time and money and commitment with these homeowners. The resolution of doing some additional work on the site other than what we're talking about is totally, totally opposed to by the council lady, the representatives of Traymore who are here and will echo that, and my client. We don't want to disrupt it for these folks that have lived there. Some have been there many, many years. So we respectfully ask that it be dealt with here favorably. Thank you for letting me say that.
Thank you, Mr. White.
If I may be heard,
Sure, Mr.
we are
Albright.
with Marshall Albritton, attorney in Nashville, representing Traymore. And I realize the technical nature of this and that you good people have to make a decision, based on that. But I did want to say on behalf of the homeowners that they actually employed a consulting engineer to look at this, Jim Armstrong Engineering. And the benefit of compliance to this association was nil. And the disruption to the folks that had bought their homes to achieve this minimal level of benefit was substantial. And so I wanted to let you all know that the homeowners really do not want to go through a process where there's a lot of construction and activity that disrupts homes they've lived in for years for really no benefit. I think it's been said, and I think that I've heard some of the committee members say that, but I also wanted to say that on behalf of the homeowners. They are enthusiastically in support of this variance request and the planting, and they are vehemently opposed, if you can be, to the idea of coming in and doing all this disruptive excavation and all the things that would need to be done for their homes. And that just hadn't been said. I think it's been understood, but on behalf of the homeowners, I wanted to say that to the committee. So thank you.
All right, I've got to go back. I don't understand this. We bring who in front of the environmental committee? The land is now owned by the landowners and the homeowners association.
Yeah, it would certainly be harder to do presently.
That's what I don't understand. Quite frankly, you guys, I think, are asking for something you don't even have to get. And so I don't really like rubber stamping uncompensated fill when, quite frankly, it should have been handled a long time ago. And I understand you guys are completely different from the people that allowed the thing to keep going. But this Metro lost its ability to do this a long time ago, in my personal opinion.
Did I misunderstand? During this process, were you asked to come before the committee? I mean, was that part of what was discussed?
That is my understanding, that there's this outstanding grading permit and that Metro wanted it closed.
Okay.
Nothing would have ever come up. I think everybody would have gone their way, but for the fact that with their diligence, I'm not being disparaging, with diligence, the staff of Metro Stormwater said, would you really work with us to try to get this off the checklist? Nobody had any idea it'd take this much time and this much effort, but it did, and they did it, and they did it right. And so we're here primarily at the request of the staff to make sure this is addressed, and that's the right thing for them to do. Despite this tortured path, that's it. So, frankly, I'm not concerned about what the environmental court is going to do in this matter. It'll never get there in the first place. But I'm asking that it be approved today so it's off Metro's checklist and it resolves it.
Well, I understand. And the reason I asked that is I don't get the sense here that Metro would want to pursue this in environmental court. And so I think that the reason we're here is so that we can just somehow address this and move on.
That's my understanding.
Okay.
Yeah, and I would just add, we've never taken a case like this to environmental court. It's just a very, very unique circumstance. Staff has worked with this site now for years, trying to remedy this, trying to pursue every option. When we got down to the point where they were looking at trying to impact buffers, there seemed to be some reconciliation of the impact to the site versus what we were trying to do. I would say that I would not be comfortable knowing there's uncompensated fill on a site without at least pursuing it to some degree, regardless.
I think we just, although I understand we have philosophical differences or whatever, it just appears to me we just need to bite the bullet approve this variance and move on.
Yeah, and whatever the committee decides, we're fully willing to incorporate that. But this was a path at the time, and we've been pursuing this now for several years, that we felt like it needed to take.
And if I could add one, sort of minor note, but something that we have tried to do better in the last few years. Early on, when I began working with Stormwater a little over 10 years ago, we had a couple of matters where a condition had been memorialized in a note, like the highlighted note we saw at the beginning of the presentation. And we have found that those have a tendency to be ignored. And so more recently, when we've had conditions like that come before the committee, we tended to require like a recorded real covenant or something like that instead of a note like that. And so that's just one aspect of it, but that's been a change in our practice or recommendations to the committee in terms of how to memorialize something like that we think is an improvement. And that wouldn't happen now, although it did happen sometimes back then.
Mr. Chairman, I got a point of order. Do we have a second on the motion?
No.
This question is for legal. So it's your recommendation that if this variance were approved, you're recommending that and maybe just keep me honest, that the language that either goes into the letter to them or into the minutes for our report says something about memorializing, or if that's not what you were indicating, is there a recommendation of language that could be used so that this does not set a precedent?
No, what I was saying just a second ago actually is not something that was the condition on the original variance that was granted like 2006 or 2007. So, and I'm just saying, if we had been in that situation, if we were in that situation now that we had been back then, we would have done it differently based on what we have learned from our mistakes. Or we would have recommended that y'all do it differently. But I don't think that pertains to the current situation at all. I do think that the current situation, there's no need for a condition like that.
So I want to just rehash or renew my motion so maybe we understand it, is that we recognize this is a very unusual situation. This is something that's been going on for a number of years. To the uncompensated fill only has an effect within the limits of this development. The residents that live there support this. They recognize that to come in and to remove this material is going to create much more disruption to them and much more disruption to the buffers. And as noted by Dodd, the invasive plants need to be exchanged with something non-invasive.
And I need to ask one more question. Did FEMA grant letters for both bridges?
No, sir. The 40-acre tributary is not in the flood zone, so it's not even in the model that was submitted.
But I still have a concern, that, we already have a different flood condition due to one of the bridges. Now we have an outstanding condition that's been unresolved. I just don't like the position that we're in. Appreciate very much all the effort and time that's been invested. It's a shame it's gotten to this point.
I'll second the motion. Our job's not to correct mistakes in metros. It's just and I don't think the Beazer has any liability that I can tell. I just, and they can't make the homeowners take the dirt out. I mean, I don't even know why we're here, other than we're correcting our own stuff, and I'll second the motion. But any discussion on the motion? Seeing none, let's take a vote. All in favor of the motion, say aye.
Aye.
Any opposed?
One.
All right, that's the record. The motion's passed. Thank you, guys.
Mr. Chairman.
Thank you very much.
Thank you for your courtesy.
Mr. Chairman?
Yes, sir.
I have to recuse myself, I think, on the next two items. Is that right? So,
Golly, I'd like to go do some other stuff, too.
I think it's the next two. This one,
there's one there? Okay. All right.
All right.
I'll be around.
We need to change the order for you?
If the other applicants, yeah.
Might as well
they're both
ask
here.
them. If
Yeah,
you can go out of here, get out of here.
Fine, if you want to do that.
Guys, if we could, I want to see if where's our thing? So this is is Heron Point here.
Thornton's Grove is here.
Thornton is the next one on the list, but Heron Point is the one that you don't have if you don't, you're not accused.
No, he's involved in Heron Point too.
Okay. Which two are you involved in, though?
Thornton and Heron Point.
Oh, so we'd have to hear Platinum Storage.
And Platinum Storage is here.
Yeah,
They are?
I'll be here for that, for platinum storage. All right.
Do you want to move the order so that you can get out of here?
We'll do that.
Did you plan on leaving?
Okay, that'd be great.
Yeah.
Sorry.
Sorry, guys, we're going to put one in front of you. So if Platinum Storage would like to come up, we'll go ahead and get started on that one.
No, Michael does. Kevin used to be my partner.
The committee members don't get paid, and so if we can make small changes like that to help guys and ladies do more of the business they get paid for, then the better. If we could, were you here when we read the opening statement?
Yes, sir, I was.
Were both of you? You were not? All right, let's read the opening statement again.
Our opening statement. If you're not satisfied with the decision made by the Stormwater Management Committee, you may appeal the decision by filing for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the committee's decision. You are advised to seek the independent advice of legal counsel to ensure that your appeal is filed within a timely manner and that all procedural requirements have been satisfied.
Thank you. If that, we'll turn to the staff for a brief summary of the request.
Thank you. My name's Aaron Thomas with Metro Water. We are looking at case number 2018-00026, case name Platinum Storage Bellevue, located at 7860 Learning Lane. Parcel number 15500009000. The inspector is Lee Nelson, Council District 35. Dave Rosenberg. The applicant's request is to allow the following stream buffer disturbance for a sidewalk and a variance from buffer sign requirements. The applicant is Flynn Stowett, LLC. The representative is Alan Mayer with Thomas & Hutton Engineering. Stormwater staff has no comments. Codes has no comments. Planning says it's consistent with the approved final SP site plan, and Greenways defers to comments of the Stormwater Management Committee. Thank you.
Okay, thank you very much. Now we'll turn it over to the applicant for presentation.
Good morning, members of the committee. My name is Travis Todd with Thomas & Hutton Engineering. This is Alan Mayer with our firm as well. We're here on behalf of our client, Platinum Storage Group, who is the developer of this project. Do we have a site plan that we could show? Okay, there we go. So you can see here, at the bottom of the page, if we could zoom in just a little bit. This project is development of a three-story self-storage building at the corner of Collins and Learning Lane in Bellevue. To develop this parcel, we are, per MCSP, we are putting in a grass strip and sidewalk you'll see along Learning Lane, a 6-foot grass strip and a 6-foot sidewalk there, which is required per the MCSP, the Major Collector Street Plan. There is a channel that runs through the site, runs north to south through the site. It doesn't appear, well, it's very light on this, the existing topography. The first 15 feet of that channel, as it leaves the box culvert that comes underneath Learning Lane, was determined by Metro in 2008 to be a stream. So 15 feet of length there, has 30-foot buffer, water quality buffers on either side. In order to construct this plan and install the grass strip and sidewalk as shown, we actually have to extend the box culvert that comes underneath Learning Lane. That'll be an open bottom box culvert so that we can fill in that area and construct the grass strip and sidewalk as you see here. From that point, after the stream determined portion ends, the rest of the wet weather conveyance will be rerouted through the open bottom box culvert as you see kind of snaking around on the west side of the site to create a development pad for this building. So our variance today, the request today is that we may be able to disturb that first 15 feet that's determined as stream in order to put in the grass strip and sidewalk that are required per MCSP. So we did not propose an alternative plan as part of this because there isn't one. We have to put in the grass strip and the sidewalk. We are proposing additional TDUs as mitigation. I think 14 TDUs are required, and we're proposing 80. So we're heavily planting the perimeter of the site. We've got 2 bioretention areas that will be, planted per LID requirements. So that's the mitigation that we've proposed for the variance that we're requesting, and we'll be happy to answer any questions that you may have.
Is there anyone from the public here to speak in favor of or in opposition to this variance request? Seeing none, turn it over to the committee for questions and discussion. I'll start off and make sure. There's a stream right now running through the middle of the site, and you're putting it in a box culvert and running it around so you can build a building?
There's the first 15, if you start at the south edge of the site, which is Learning Lane, right there, you'll see where our box culvert begins, right where the mouse is right now. From that, at the mouth of the existing box culvert there, the first 15 feet of that stream heading north, of the channel heading north, was determined to be a wet weather conveyance. A stream. Thank you, Alan and Rebecca. A stream, and it has 30-foot water quality buffers on either side. So that first 15 feet. After that, it's a wet weather conveyance continuing through the site. The wet weather conveyance we are rerouting with this box culvert. So it's that first 15-foot portion that we have to fill, where we're filling in the actual stream buffer to construct the grass strip and sidewalk. Right now, you've got an edge of pavement, a pretty broken edge of pavement here. There's a guardrail that's leaning over, and then it drops straight off down into the channel. So we're fixing that and adding this grass strip and sidewalk, and that's the portion we're requesting the variance for.
Another part where it said the blue line ends 15 foot into the middle of the site. Is that?
So if you look at Learning Lane where Rebecca has her hand on it,
yeah,
that's the existing road, and 15 feet beyond that is the stream, and then everything beyond that is a wet weather conveyance and doesn't have buffers. So it's just that small little section where you can see the red and the yellow highlights is the stream, and then everything beyond that is not a stream.
So from my ignorance, how is that point determined? Why is that the point that it becomes a stream versus wet weather conveyance?
I would be ignorant in that too. I'll defer to Rebecca.
It was a change in grade at that point. The first 15 feet were of a lower level and had continuous water in it, and there were, it was 10 years ago, but I think we saw some fish.
It backs up here through that box culvert and kind of pools at that point, and that's kind of the upstream, portion of, where the water is permanent, essentially. And after that, it's wet when it rains. A few hours after an event, this channel is dry.
So it's a wet weather conveyance. This is where it crosses the road.
Yes.
because of the terrain at that point, it probably pools up right there and doesn't dry up.
That's correct.
And so that's why we called it a stream. So, all right.
Is the pooling?
If there, one more, I'm sorry, Anna.
Sorry, go ahead.
Aside from that, you would not be in front of this committee asking for a variance?
We wouldn't. If that was also a wet weather conveyance, we would just propose the routing like we are today. We just wouldn't be here for the variance.
All right, that's helpful to me. Thank you. Anna?
Which way is the water running, from north
It comes
to south?
north and flows south like this right now.
And what happens on
Yeah,
the
that
south
street view.
side?
Here, it goes through a long box culvert under Learning Lane, under Highway 100. It goes behind the Kroger Shopping Center and then finally outfalls. So it's
So it's just that tiny little piece.
yeah, I mean, all this it's boxed. There are portions of this that are as it crosses under here. And so if you go right back up, there's 15 feet right here that are exposed, that aren't boxed. And we're wanting to take that right there as we reroute here. That's the portion we have to get a variance for to put the sidewalk in.
Okay.
And it's a stream downstream, if that's what you were asking.
Yeah, that's
Yeah.
what I was
That's correct.
getting at.
Is that buffer existing now, those trees, that tree canopy, is it there now? It's shown in the photograph, okay. Can somebody blow up the plant list for me? I can't, my eyes are not good enough to read this 4-point font here.
It's a big sheet. I apologize for that being so small.
Are we making sure there's nothing Chinese in here?
I told Roy a while ago, I said, nobody liked my joke, did they? He said, no.
We're all business.
Okay, so we need a little levity around here occasionally. It just needs to be funnier. So, okay, I don't see anything. My main concern is just losing the canopy. I agree the stream is box culverted. It's not really a natural channel anymore. Is that correct? Is it entirely box culverted, open on the top?
It's box culverted under the road and then is daylighted again.
Okay, so it's an open stream channel. Okay, with a canopy. So it's not a concrete lined.
No, for the 15-foot portion before it goes under Learning Lane, it's open.
Okay. Well, so there's no way y'all could just kind of protect that portion of the site and just avoid it?
If we can't, we have to put in the grass strip and sidewalk per the major collector and street plan. It has to go through right here. So, I mean, there's no way to get around that.
And normally, we would request that they seek a variance possibly to the grass strip, but considering that there are a lot of children that use this area, it seems that for safety that the grass strip is important.
Okay.
If you've seen this photo, that's the condition today. The school is just beyond us, and there's a major intersection here, and there's nowhere for them to walk today. So, our client didn't even want to pursue getting out of the grass strip and sidewalk because they committed to the community to build that pedestrian infrastructure.
Does staff feel like the plannings properly mitigate the impact? Okay.
A motion to approve as requested.
Second.
See a motion and a second. Motion to approve as requested. Any discussion on the motion? Seeing none, let's take a vote. All in favor of the motion, say aye.
Aye.
Any opposed? Seeing none, the motion carries. Variance is granted. Thank you.
Thank you. Appreciate it.
Mr. Chairman?
Yes, sir.
I did want to note that we do have other staff members that you typically don't see that are actually here, and we are trying to give them more exposure to what we have before the committee. So like Aaron mentioned earlier, Aaron Thomas, he's been with us for a little bit of time, and we have some more staff that we're going to try to slowly integrate into the Stormwater Management Committee and get them before you guys.
Wonderful, thank you. Okay, and I apologize, and I appreciate everybody rearranging their schedule just a bit, but let's gearing the next matter up. Thanks for helping us. Now we're going to Thornton Grove Green, LLC.
Thank you, Chairman. This is case number 4 today. We'll call it case number 3, 2018-00024.
I apologize. Yeah, we're now going to have a recusal of Mr. Dale for the next 2 matters, and
Yes,
then
sir.
we'll move on. Thank you, Mr. Michie.
Thornton's Grove, it's located at 3500 Brickchurch Pike, parcel number 050-000-12900. The inspector is Boots O'Hara. It's Council District 3, Ms. Brenda Haywood. The applicant's request is for number 1, relocation of existing stream along Brickchurch Pike and its buffers. 2, disturbance of 7,965 square feet of the new buffer along Brickchurch Pike to provide required sidewalks and road improvements. Number 3, permit accesses to be spaced less than 1,000 feet apart across the proposed buffer. These are proposed at 600 feet. And number 4, to permit 14,782 square feet of disturbance to the floodway and floodway buffer. 10,407 of it is a streaming location, and 3,880 square feet for sidewalk and roadway improvements along Brickchurch Pike. The appellant is Thornton's Grove Green, LLC, being represented by Michael Garrigan at Dale Associates. Stormwater staff requests that if a variance is granted, the channel is designed to retain the flow characteristics of the existing stream. Staff also requests that the plan utilize some container trees instead of live stakes and include a 2-year survivability guarantee. Codes, no comment provided. Planning, the variance request is consistent with the final site plan approved. Greenways defer to Stormwater Management Committee. Thank you, sir.
Thank you. We'll now hand the floor over to the applicant for a brief presentation.
Thank you, Mr. Chair. Members of the committee, my name is Michael Garrigan, 516 Heather Place. I'm an engineer with Dale Associates. With me today representing the ownership group is Kevin Estes. It looks like we've got 4 items. I'll summarize them real quick. If you have the photographs.
The ARAP photographs?
The photographs that were provided with part of the package, the actual field photographs, do you have those?
The only photographs I'm aware of, the ones with the ARAP application, are those adequate?
They could be, yes, ma'am. So essentially, what was blue on that drawing above is a roadside ditch. There you go. That's a decent picture. That's in the wintertime. There were some newer ones provided with a submittal package. But it's a roadside ditch. It's a lot of farmland. It has stream characteristics going upstream in a portion that has a buffer on it that we're not touching. But this is part of a master plan PUD. It's a large subdivision. And as part of that, we're required to do road improvements, widen Brickchurch Pike, add sidewalks on Brickchurch Pike. So that's it. Thank you. So obviously, when you're widening that road right there, you're going to have to get into that. So we have relocated that stream back. That is the orange that was on the plan of record. And we relocated it back for a couple reasons, further back for a couple reasons, mainly so that we could meander it so that the linear footage of the new stream is longer than what exists. That was a request directly from TDEC. To get it far enough to the west there so that we could cross the bridge over with other utilities, electric, water, over the box as opposed to going under the stream. So again, trying to mitigate or keep disturbance down as much as we can. The new stream will be wider than the existing stream. It will mimic its its size and shape, just be slightly wider so that it carries flow. Right now, the current roadside ditch is a little undersized, and we will plant both sides into a Zone 1 buffer and completely keep that in non-disturbance, which doesn't exist today. The second item of request is the spacing of the two crossings. You can see on the far left in that image, Winchester Drive across the street, that's where one drive has to be, just to line up with an existing drive, and we need a second to satisfy the fire marshal. And you can see that heavy gray on the drawing, that's the floodway buffer. So we're kind of pinched there, so that's the reasoning behind that. It also allows us, I'll point out, going left on the drawing, which would be north from the furthest most left access north, it stays, the stream stays intact. It won't be touched whatsoever because it's further enough away from the road that it won't affect any of the road development, nor will the buffer disturbance be necessary there. Lastly, the floodway disturbance, you can see that's pretty obvious. It's, again, some sidewalk, and then TDEC wanted us to, and the Corps wanted us to actually keep, instead of just allowing it to go to sheet flow, keep the stream going to the right-hand side of that page to connect into the North Fork of Ewing Creek. So that's the purpose of that disturbance. And one thing I will point out that's not part of your package that we just received yesterday is the flood study from Mr. Jim Armstrong that staff asked us to just verify it would be a no-rise because we are affecting or disturbing the floodway and the floodplain with the sidewalks along Brick Church and then with our new ditch. But that cut overcompensates the fill, which results in a very minimal, like 0.02 drop in flood elevation. So essentially it's a no-rise, but it's a drop. So with that, and there's a mitigation plan is part of your package. We are in agreement with all of staff's comments and recommendations, and happy to answer any questions.
Thank you very much. Is anyone here from the public to speak in favor of or in opposition to this request? Seeing none, turn it over to the committee for discussion and questions. I understand this one.
So just to clarify, you all have all your state and federal permits in hand. Do we have those in the application?
They're not in hand. We're meeting with the Corps October 14th, but we've been working with Terry, and the application's complete. They're just finalizing everything else.
I have a question. Is there a reason why the stream is kind of like naturally, you've got it graded to where it's got a nice little meander going, but then as it goes further towards the south, it kind of takes more abrupt turns? Is there a reason for that?
Are you talking
Where it
about
goes
right
back
around the
closer to
second
the road?
entrance?
Yes. Yeah.
We meandered it back so that we could get the road elevation up to a point so that we could cross over the box with all the underground utilities as opposed to going under it.
I think what you're asking is it's meandered away from the road.
Like the yellow, where it goes into the yellow piece.
Right.
Oh, once it enters the floodway.
We requested that initially we had let the stream cross under the culvert and then kind of die back into the natural floodplain that existed. TDEC asked us to tie that back into a hard point back into Ewing Creek. So we had to turn the creek back towards the road to tie it back into its natural discharge point into the creek.
Okay.
And I think we kept it straight just to minimize the floodway disturbance, but you will see on the 2 cross sections that are on that plan, that section is it's still a ditch, but it's over 10 feet wide, the section is, so we're still trying to mimic some sheet flow, but also keep the stream characteristics, trying to balance 2 different things there.
How does staff feel about the mitigation?
Staff doesn't necessarily like to comment on stream relocations. The comments we did provide were that we didn't think live staking would be a good idea. We've seen it fail a lot in the field, and so we'd rather see some plants that had a greater chance of survival.
Todd, we call those tariffs.
You call those tariffs? Okay. I got more laughs than mine did, so. I will say for the record, the applicants did laugh at my joke earlier, so that was what you kind of expect, right?
I'll say for the record, that makes no difference in your vote.
I know. Exactly. I do try to be fair, so. Let me see if I can put this in perspective. And this may be an unfair question to ask of staff. Is the stream in its original location, or was it relocated to this ditch-like shape of a channel?
I'm assuming its current location is not where it was meant to be naturally, either due to previous work on the property itself or the road that was put there.
Okay, all right, that's fair.
And I'm not trying to put Rebecca on the spot. Do you have, well, maybe I am a little bit. Do you have previous aerials beyond the latest one on our GIS, or?
And
do we have like a 2010 layer or something earlier?
And while you're looking for that, I've got an opposite comment that might give some perspective to Rebecca's comment about the stream, and that is concerning its long-term stability. Any water course that's been established for a long period of time, whether it's in its original natural location or its new unnatural location, has a record of history of stability. So this site is stable right now. It's not ideal, but it's stable. It's I think you referred to it as a ditch, but it's stable. So if you're going to change the geometry of that stream, you're introducing all kinds of potential challenges to the public interest. You'll obviously be managing your interest because you want this bridge to be stable. You want the site to look nice, and you don't want to have long-term maintenance problems with a stream that keeps moving around because all of a sudden its new geometry changes the velocity of the water, or changes the way the water erodes the banks, and so forth. Did you do any kind of hydrogeomorphic type assessment to see if you could come up with something that would represent kind of a least disturbed environment that would give us a higher confidence level that it's going to stay stable?
We didn't do any formal studies like that. Once again, I mean, we kind of both find ourselves in positions we don't really want to be in, and the fact that we're being required to widen a state road, and there's no way to avoid whether we want to call it a stream, a roadside stream, but I will agree with whatever terms you want to call it, the established water path. So we did work with the state on their morphology requirements, which aren't super
detailed,
sophisticated.
Yeah. Particularly in this kind of situation.
Yeah, but we did have environmental scientists design the cross-section for us, design the stream width and the stabilization. It wasn't I won't throw Mike under the bus because I'm an engineer by training myself, but it wasn't an engineer that said, this looks good. We had an environmental scientist do that, but I don't know what levels he went to DOT in doing that. I kind of just paid someone to do it.
Is it fair to say you made the channel wider and you made the banks more sloping so it'll carry more volume and reduce the velocity of flow through there?
Absolutely. The channel is probably about twice as wide as it is today, proposed, so velocity should be reduced.
So then staff's concern appears to be about the plantings that will keep it stable. Can you all address that?
Yeah, and Rebecca, I hate to agree with Rebecca because we never do, but she's right. I mean, I've live staked several streams over the years, and about 75% of them die. So, we don't want to irrigate it. That's kind of defeating the purpose of establishing a natural buffer. But I do feel like some half to 1 inch container plants do have a little bit more survivability, planted at the right time, and the stream don't flood too much, but we are required by the state to monitor it for 5 years and by the staff to provide the survivability of 2 years, and we agree to that. So,
and I'm sorry, I may have missed this earlier. Is that a general permit or a?
It's individual.
Individual ARAP.
Mm-hmm.
Okay, and you already have that in hand?
Of course not, because the Corps is we're waiting on the Corps. They've hired some people for like 120-day contracts, and we have one of those people.
I'm really not trying to be difficult. I'm trying to ask lots of questions and offer lots of information that help facilitate our understanding of this. But typically, we really like to see everything in hand by the time you get here.
It really is the chicken and the egg in some of these situations. We can't move forward with plans here. We want to give complete plans to the state. We've been in process in the state and the Corps for 4 or 5 months, so we're beyond all revisions. It's just a public comment at this point.
When do you expect to get your permits?
Oh, that's a loaded question. I never try to give anyone's. When I'm not in control of issuing the permit, I really don't try to speak for anyone else anymore. I've learned my lesson.
So I routinely do not vote for proposals that don't have permits in hand. Just FYI.
I understand. Once again, I sit here and say we're in a rock and a hard place. We're taking Stormwater may have a very different vision than Planning Commission and what roads look like and what's best for the environment. We don't have the opportunity to pick and choose. We're mandated by the view as a whole. And as far as permits, there's not going to be any change in the permits at this point. They've been reviewed. They're all out to public comment. The Corps is clear the side of the natural and heritage issues. So, I like I say, is we're at the point of waiting public comment.
Well, just out of just a statement of fairness to other applicants, we've told other applicants in the past, we deal with evidence here. We don't really get to deal with predictions of the future, and so thank you.
If I could just quickly say a process thing at our staff level, what we do is if you do feel led to approve or disapprove or whatever you decide to do, if you approve something and we do get some information back that results in some sort of change, we would catch it at staff level and we would bring them back to you.
You can also approve it contingent upon the state approvals being granted subsequently.
Can you say that one more time?
You could approve it contingent upon the state approvals being granted subsequently.
I know. I just haven't done that in the past. But I will say, this is a much different natural environment than we're typically concerned about having permits in hand for. If that helps anybody who wants to make a motion.
Any other questions for the applicant, for ourselves, staff, legal? I'll make a motion to approve as requested with the conditional upon approval of the proper authorities, including TDEC approval.
I'll second it.
Can we add that they'll work with Metro on the landscaping?
Yeah, that's a good point. Yeah, let's make that motion to conditional upon TDEC approval and working with Metro on the live staking. Can I get a second on my revised motion?
If the council will let me withdraw my previous second as a, okay. I know friendly amendments are technically not liked in Robert's Rules of Order type language, but I will accept that as part of my second, so as a complete motion.
All right, so the motion on the floor, which has been seconded now, is a motion to approve as requested, conditional upon TDEC approval and working with Metro staff on the live staking planting. Any discussion on the motion? Seeing none, it's up for a vote. All in favor of the motion, say aye.
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 Any opposed? Seeing none, motion is granted. Thanks, guys. Last but not least,
That's a good series of questions on that first case. I mean, second case. It really was.
it's a little confusing to me. All right. The next matter is before us. What's the name on this one? Just Zero Bell Road?
This one's Heron Point. Heron Point.
Yeah. Where does it say that on here? Am I just missing something?
No. I'm gonna have to start going back.
Let's start making let's add something here where I just know what to call it.
Okay.
Good. Applicant here? All right, thank you very much. Were you here earlier when we read an opening statement on the appeal process and what happens with that? Yes, sir. Okay, wonderful. With that, we'll turn it over to staff for a summary of the request.
All right. This is case number 2018-00025, Heron Point. It's at Zero Bell Road. The APN is 121-0000-7900. Inspector is Donald Irves. Council District 13, Holly Hueso. Applicant's request is to allow the following: driveway encroachment on wetlands. Proposed wetland disturbance is 0.16 acres, and wetland buffer disturbance is 0.1 acres. The appellant is Hybrid and Ball Land Design, represented by Adam Sager, Dell and Associates. Comments: Stormwater staff had no comment provided. Codes had no comment provided. Planning, consistent. Greenways defers to the comments of the Stormwater Management Committee.
Wonderful, thank you. We'll turn it over to the applicant.
Thank you. My name is Adam Sager. I'm with Dale and Associates. We are the civil engineer for this project. To give you a background on this, it is a phase 2 of an existing development. As you can see on your screen, the bottom part is an existing apartment complex, and it is included in an overall PUD, plan unit development. I don't know if you have on one of the drawings, you'll see we have an interesting entrance configuration off of Bell Road, but there is a history behind it, and I want to make sure that we all understand why we're proposing the road in the location we are. When phase 1, when the overall project was put before the Planning Commission, it was a requirement by the fire marshal to have 2 entrances. And the entrance that you see on the screen right there is the first entrance, and there's going to be another entrance to the north of that that has been required by planning and the fire marshal to access the phase 2 of the development. Existing infrastructure was installed in anticipation of this, and so that existing road that's going in is stubbed out to anticipate the location of where we are crossing the wetland. And we had to do that to maintain 2 points of connectivity, or 2 points of access, to Bell Road, and also to make sure that we are connecting within the community. So we have to cross the wetland. And we met with staff trying to find out what is the best option to get from A to B. We looked through a lot of different alternatives. We moved the drive to the north, the south, the east, the west, and the original drawing done on the approved planning design was more kind of at a skewed angle across the wetland and had more disturbance than what we're showing now. And so what we did is we went back, and you can see from that existing road on the bottom of the page in the dark gray, we started to bow the road out to the west, pull it further, like that, and get a better kind of direction across the wetland to try to cross it perpendicularly rather than at a skewed angle. And we tried to move that driveway up the wetland as far as reasonably possible to only to get in more of a narrow area. As you're looking at your screen, the area of wetland that is being disturbed and encroached upon, including the grading, is 0.1 acres, and then a little bit more than that in the buffers as you go to and from on either side. We knew we had to cross this. We know that it's impacting an existing wetland, and so we want to mitigate as much as possible within our capacity to do so. There's a few things we did on the site above and beyond what we would normally have to do. One, there are ephemeral streams to the right. There you can kind of see them on the screen you're looking at, and we kept those completely non-disturbed. Instead of encroaching upon those like we could, we left those and we regraded and we laid out the site entirely to avoid those, try to keep as much natural streamways as possible. Another thing we did is added a lot of trees, as you'll see in the mitigation plan.
Oh, thank you. I was being loud and I'll have to quiet down now. There's a mitigation plan provided by Hebert and Ball. Most of this site is going to retain all of his existing trees, and so we don't have to plant one more tree to meet the zoning ordinance for tree density. And so we're proposing, hopefully, what we believe a robust tree planting plan of all native species to help mitigate the impact. There are sinkholes on this site. We're avoiding all but one of those sinkholes. And whenever we encounter sinkholes, we have options on how to treat stormwater. We maintained the LID, low impact development treatment for this project above and beyond what would otherwise be required on a project like this. And so we've done what we could on site to help mitigate this. We've explored all of our alternatives to try to provide the least impact possible. And we request a variance from, I believe it's a letter that was issued stating that any access across wetlands needs to go before this board. And so I'm here for any questions and appreciate your approval on this matter.
Thank you. Is there anyone here from the public speak in favor of or in opposition to this variance request? Seeing none, we'll turn it over to the committee for discussion and question.
What do you think, staff?
I will say that we did meet with the applicant before, and we had suggested to him to look at other options before coming here. And they looked, making the entrance to the north, and the slopes just wasn't accommodating.
So in this case, looking at other options actually has options that are not good alternatives.
Exactly.
What about the mitigation he's proposing? Are we happy with that?
I think the suggested plantings and more importantly, the areas that they're leaving alone helps to mitigate what they're proposing.
Would you be willing to accept that friendly amendment to your application? Your variance.
I'm sorry, I was trying to navigate this. Could you repeat that?
She'll have to repeat it because it was her comment.
No, I was saying that we feel that the plantings they're proposing, plus that the areas that they're leaving alone, compensate for.
Okay, so I thought you were saying you wanted some other areas planted. Okay, I missed. Evidently, I wasn't listening. Okay, so it sounds like we're copacetic on everything. All right, I see a head nod. All right. Lots of head nods. Okay. Move to approve is presented.
I'll second that motion based on the fact that there is a hardship on the property that you can't access the other portion of the property without crossing the swelling. And they're minimizing their crossing impact. Got a motion and a second. Motion's up for a vote. Do we have any discussion or whatnot on the motion?
I just want to add that mitigation is a viable reason for granting variances. It replaces lost functions and values of natural systems. So we're when I vote for these type of things, I'm not voting for a variance. I'm voting for a replacement of function and values. So.
Any other comment or discussion? Seeing none, all in favor of the motion, say aye.
Aye.
Any opposed? Seeing none, the motion carries. Variance is granted. Thank you, sir.
Thank you all.
That concludes the last matter on the agenda. New business, I'll start off. I just want to say my critiques earlier of Metro had nothing to do with the people in this room, and I just want y'all to know that. That was something that should have been, my irritation was that was stuff that happened 12 years ago.
I heard you say other people, Mr. Chairman, in the past.
I just want to make sure I made that clear. I appreciate that the staff today was trying to get that cleaned up and did everything they could to get that done properly. So
I will clarify that we didn't have a bond on it because this was a private development. So I know it was mentioned about bonds and bonds released. It's not that we released the bonds. We didn't have a bond to release because it was all private.
There was no bond ever, yeah. Understand.
If I can just, Roger Lindsay, if I can just touch a little bit on that.
Sure.
12 years ago was a long time ago. That predates my tenure here by 2 years. We brought them back in as a means of trying to close that project out. When Michael described some of the processes, he described a scenario in which a developer starts with an approved plan, and when it's all finished, he comes in with an as-built and says, here's the as-built, at which time we reviewed that as-built and said, this is not what was approved to start with. Mm-hmm. So when we brought Beazer back in the last 2, 3, 4 years, it was not to try to reach an easy, quick solution to signing off on this project. It was to see if there was a way to fix the issues that had been created because it hadn't been built in accordance with the original plans. And that's when we got into a fairly extensive discussion about, is there a way to go back in now and remove some of this excess fill without compromising the foundations of the buildings that now exist, that have been sold to owners who have been living in them for some number of years. And then what we found was that we'd have to remove a lot of mature trees. We have to create a whole new construction zone in a project that had long since been finished and walked away from by the developer. Mr. Williams with Beazer has been diligent about coming back every 4 or 5 months for the last 2 or 3 years. We've had meetings with them as they've come in with their support from Neil Schaefer saying, we're looking at everything we can conceivably look at to find a way to make this project balance out, to make this not be an uncompensated fill kind of an issue. And the end result was, they approached Dollar General, an unrelated next door site, and said, can we slice some dirt off the back of your lot to help us balance our cuts and fills? And there was just no good way to make this happen. And I think it was important that the representation of the Homeowners Association, they came in and said, the people have been living quietly and in quiet repose for some time in this neighborhood. Now to create a construction zone in the middle of it, chop down a bunch of trees, haul out a bunch of dirt, we don't have any interest in proceeding with something like that. So that's kind of close the loop on this. And since then as well, there's been, a new set of flood maps issued. This creek has been modeled and mapped based on the conditions that exist today. So,
right. There are processes in place now where that can't happen, correct?
One of my early concerns, going back 10 years, and I got a nice lecture from Roy Dale about it, I asked why nobody was on these sites watching this construction go in. And the reality is that if you were building a water or wastewater treatment plant, and that's the industry I came from, there was always resident engineering on site checking all the steel before the walls were poured. Yeah. We do have resident inspectors when we install water and sewer lines on metro projects, even development-related projects, because that's our infrastructure ultimately. We're going to accept that infrastructure. We want to make sure it's put in right. But from a development perspective, we don't have the staff to keep someone on site to watch what goes in on a day-after-day basis. And as Roy pointed out to me some years ago, they're delivering a set of approvable plans at the beginning of the construction, and then the owner's saying, we'll call you when we're done and you can create the as-built. He said, almost never does one of my clients retain me to provide any on-site supervision on a project going forward until it's essentially finished, when he needs an as-built or a certification that the project's been built in accordance with the approved set of plans and specs. So it's a great challenge, because oftentimes it's a challenge to get a builder to accept the fact that there's costly stormwater features that have to be incorporated into a new development. And to add on the additional cost of maintaining an engineer's representative on a day-after-day basis is just not part of the budget for a development type project.
When they do the sediment control plan, they have to show the sediment control fence around the site, correct?
And that's a lot of what Michael and his group, Dale Binder, they're out there on a monthly basis. They try to get by every project on a monthly basis to make sure that the EPSC, all the erosion control stuff is still in place and it's doing the job it's supposed to do. But
so y'all would pick up on whether they're grading in the floodplain without any right to do so.
Yeah, there is an outline of disturbance outlined on the plans, as well as EPSC, and the system, the way it's set up is, and we've got 750 plus active grading permits right now that we're overseeing, is that the understanding is on the developer that you've got to build the site per plans. We have the pre-con meeting with the contractor. We lay everything out. Our inspectors do go out and they bring things up as they become aware of them. Where it gets a little bit gray is this ongoing conversation that the engineers or the developer feels like at the end, at the as-built, they can make it right. But yeah, there should be, and we're working with sites all the time where they're outside their limits of disturbance. I would add one thing, maybe is just a ray of sunshine in this whole thing, is if you go back 12 years with the thought that we are issuing between 200 and 300 grading permits a year, probably more than that, this obviously was a very unfortunate situation, but with all the sites and all the activities in the floodplains and how they're having to work with development services and our inspection staff, if there's one positive to take, this is probably the one time I ever remember something like this coming up. I know we don't have any on the radar and don't envision having any come here again, so it's a very unusual circumstance, but our staff, I just want to assure the committee, our staff is continually looking at sites, reconciling what's on the plan, and giving folks feedback if it's not. Now, like I said, sometimes the developer and the engineer feels like they could work it out at the as-built, and we try to be respectful of that. If they can't, then they know the way the system is set up. We hold sign-offs until everything can be resolved.
And that change that they made wasn't just a change that was done out in the field by a contractor. It required the civil engineer, it required the structural guy on the plans. when they changed from that wall going to a regular slab on grade, there were
Yeah.
people involved that should have known to stop. You can't do that unless you get Metro approval.
You know, again, generally, you almost would think something like that was planned, and there'd been some thought given to that.
Somebody had to prove it. An engineering, a licensed individual had to approve those changes.
One of our tools,
or knew about them at the least.
One of our tools that we have that usually helps gain compliance is UNO sign-offs.
Right.
And, you know, we've been dealing with our friends at Codes about making sure that, you know, we have adequate representation in the building permit process as far as closing out permits. You know, when there's homeowners, or we'll say home builders, that are large, they may self-finance people, and they may not need UNOs. So I'm not sure, not to defend staff, I'm not sure there was anything that was really, may have been done wrong. We may have very well not had a final UNO sign-off on these last units. And that's one of our biggest tools is a final UNO sign-off.
Oh, right. Yeah, what I'm saying is that the engineer of record.
Sure.
And maybe they weren't advised, but somebody who did the plans because of the structural change that was happening.
And I guarantee
that was significant. That wasn't something that some builder just did without anybody realizing they dug a hole in the wrong place. That wasn't just digging a hole in the wrong place. This was something that was thought through.
And I can assure you that that Dale does send out reminder emails to applicants all the time, including this one, constantly saying, hey, we're still waiting for you to become compliant. We need to get as-built approved. So I'm pretty sure he's been sending these emails, you know, several times a year for the last decade.
He does.
Yes.
And apparently UNOs are quite effective at getting people's attention. I mean, it hadn't been a month since someone recently said, I've got a friend who's having a lot of trouble with some fine details on a UNO, so something wasn't right.
Thank you.
That may have changed a little bit too. There was at some point, I want to say like in 2002 or 2003, I think it was a circuit court case, Hilton Gardens, in which a case was decided against Metro Codes for insisting on a landscaping requirement being completed prior to a UNO being issued. And they said that the conditions that you could withhold a UNO for had to be related directly to the building. Stormwater then amended its code provision to specify that the council actually amended the Metro Code to specify, because the Hilton Gardens Inn was decided based on the wording of the Metro Code, to specify that the stormwater requirements were actually integral to that permitting process, which would have fixed the problem in that earlier case law. So there was a point in time where codes may have thought they did not have the authority to withhold a UNO for non-building related conditions.
Interesting.
So that may have been, I don't know if that played into this particular case at all. And I'm also glad to clarify other enforcement procedures, if that would help in terms of, you know, the NOV process or the environmental court process. It is very rare to use environmental court pleadings in a stormwater context. It has happened in a handful of cases. The normal enforcement is more the administrative penalty process. You know, that doesn't, I mean, you can issue stop work orders in that context, and I think we can withhold permits on later phases of the same project, but once the project is like completely done and completed, you don't have like anything that strong in the administrative enforcement context.
We also can, there's a bad actor clause that if an entity on one grading permit is failing to come into compliance, we have the ability to consider whether to issue them another grading permit elsewhere if they're not compliant.
Yeah, and so sometimes you really do come down to it, especially when a project is completely finished, where maybe there's not a lot of teeth in any of our enforcement mechanisms, and so environmental court is an alternative that's available for any Metro Code violation. And when you have a project that wouldn't be in compliance but for a variance and they're not complying with the conditions on their variance, then that would be a Metro Code violation and appropriate for environmental court. But we've rarely used that. There have been a few instances that I've been involved in, and a lot of times we've actually been able to maybe prepare a speaking complaint or something like that and then get voluntary compliance in response to that. But I'm not sure there have been many. There maybe been a couple cases in the last 10 years that have actually gone to environmental court and where we've actually gotten environmental court, like injunctive relief, where, there's penalty of contempt of court if they don't comply with what either the court orders them to do or not do. So.
Yeah, I would just say we're a little different than codes. Codes utilizes environmental court a lot. With us, it is a very last resort, and it's just almost nothing, never something we pursue. If we would rather work with applicants than to go that route.
A lot of times you get a lot more if you do.
All right, thank you. Any more new business?
Move to adjourn.
Looking for a second.
Second.
Motion to move to adjourn. All in favor, say aye.
Aye.
Opposed? Seeing none. Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.org.